Now, in a big relief for India's opposition leader Rahul Gandhi, the Supreme Court has suspended the conviction orders against him in the Modi surname defamation case. Now, the top court's orders now pave the way for the Congress leader to now return to the parliament after officially restoring his status as a member of parliament. Moreover, Rahul Gandhi will also be able to contest national elections which are due next year shortly after the court's decision. The leader also issued a statement at a press conference as well.
आप सबका यहाँ बहुत बहुत स्वागत। आज नहीं तो कल, कल नहीं तो परसों सच्चाई की जीत होती है। मगर जो भी हो, मेरा रास्ता तो क्लियर है। मुझे क्या करना है, मेरा क्या काम है, उसके बारे में मेरे दिमाग में बिल्कुल क्लैरिटी है। जिन लोगों ने हमारी मदद की और जनता ने जो प्यार और सपोर्ट दिया, उसके लिए मैं बहुत बहुत धन्यवाद करता हूँ। थैंक यू।
Now, the top court has closed the contempt proceedings against the opposition leader but has warned him to be more careful in his choice of words in the future, especially in the aftermath of the remarks that were made by him on the surname Modi and how he had linked to the surname Modi with what was happening in the country. The top court also said that the remarks were not in good taste and people in public office should, of course, maintain a certain level of restraint in what they say. Meanwhile, several Congress and other party leaders have congratulated Rahul Gandhi and have welcomed the decision of the Indian Supreme Court in this matter. Now, the Congress Party has formally demanded the restoration of Rahul Gandhi's Lok Sabha membership. The Congress leader Adhir Ranjan Chaudhary met with Lok Sabha Speaker Om Birla and has urged him to restore Rahul Gandhi's membership immediately. Now, Rahul Gandhi had earlier this year been convicted of a defamation case when he had used the name Modi in a certain manner, and he had been disqualified from his position as a member of parliament for his comments that were linked to the surname Modi. And we also earlier spoke with Dr. Kapil Sankla, who's an advocate at the Supreme Court, and this is what he had to say on this issue.
The observation made by Honorable Supreme Court was either in passing or would have far-reaching consequences in similar matters in which a litigant who is a politician will come and say that the only reason the maximum sentence should not be awarded is because he is an elected representative and is thus entitled to some special benefit. It is my fear that this kind of defense is not far at sight with the observation made by the Honorable Supreme Court. However, if the observation has been made by the Supreme Court only in passing during the stage of arguments, then I do not see any encumbrance or far-reaching liabilities or issues in similar cases in future. What I do see is that the trial court and the high court should have been seized of why the maximum punishment is being given. Although they are entitled as the trial court to do so, it can always be challenged in revision. But the Honorable Supreme Court has said that in similar cases, unless shown that there is some bias or non-application of mind, they usually do not enter the domain of why the maximum punishment has been given.